Hey everybody, welcome back to another edition of Freedom Steel. Todd Vandermine, former NRA contract lobbyist, Illinois gun law guru, and we have some breaking news here this afternoon. Cue the alert. So this morning, a few hours ago, the Fourth Circuit Court of Appeals has issued its decision in Maryland shall issue versus Moore. This is a challenge to Maryland's FOID card style handgun purchasing license. And in a 2-1 decision, they found it unconstitutional. That's right. Maryland's FOID Card Act is unconstitutional under the New York State Rifle and Pistol Association v. Bruen standard. It was a 2-1 decision, and the dissent, there might be a whole separate video just on the dissent in this, but they found and they annotated that they sat there and noted that the state of Maryland was unable to come up with any historical analogies to a 1791 type law that would allow for this type of pre-purchase permitting proposition. So you have Judge Agee and Judge Richardson, who were the majority on this 3-judge panel, with a Judge Keenan, who was against it. And from the oral arguments that I remember hearing, I believe it was around February, that you could tell she was just not having it. Judge Richardson wrote the decision for this panel. And as we get to some of the juicy tidbits here, so in the beginning, at first blush, the answer to the initial question seems obvious. Here, plaintiffs allege that they are adult citizens who are legally eligible to own firearms. So they fall within the amendment's definition of the people. See Bruen, noting that the people whom the Second Amendment protects include at minimum, ordinary law-abiding citizens. And plaintiffs here say they seek to own firearms for lawful purposes, a point that Maryland does not contest. Indeed, the amendment's plain text extends prima facie to all instruments that constitute bearable arms. The Supreme Court has held that the specific weapons here, handguns, are protected arms. So there is the beginning. And yet part of this decision is another decision that talks about those ancillary rights. So yet there are a few wrinkles to iron out. To start, you might note that the amendment's text protects only the right to keep and bear arms, U.S. Constitutional Amendment 2. But on its face, the challenged law says nothing about whether plaintiffs may keep or bear handguns. It only restricts plaintiffs' ability to purchase, rent, or receive them. How then does the law regulate the right to keep and bear arms? The answer is not complicated. If you do not already own a handgun, then the only way to keep or bear one is to get one, either through sale, rental, or gift. They leave out build your own, manufacture your own. And the challenged law cuts off all 3 avenues, at least for those who do not comply with its terms. That brings us to the next wrinkle. The challenge law does not permanently prohibit plaintiffs from acquiring or carrying handguns. Instead, it imposes a certain requirements that they must meet before they can obtain a handgun. And those requirements rely on objective criteria, which plaintiffs admit they can satisfy. Once they do so, the law commands that the state shall issue them handgun qualification licenses. Why is this a big question? Because if you'll remember, in the state court FOID card challenge in Illinois, they have argued ad nauseum that Bruen has this single line, or there's something in there from the Kavanaugh concurrence that talks about, hey, shall issue regimes are okay. But in the context, it was a shall issue regime for carry licenses, not a shall issue permitting regime, not a shall issue FOID card, not a shall issue permit to purchase regime. It was a shall issue carry license. There's the distinction. And the other side has been trying to hang their hat on this ad nauseum. But even though Maryland's law does not prohibit plaintiffs from owning handguns at some time in the future, it still prohibits them from owning handguns now. In order to get a handgun, plaintiffs still have to follow all of the law's steps. And although they will be able to complete each one, it is impossible to do so right away. Plaintiffs can't receive a license to legally acquire a handgun until the state reviews their application, which can take up to 30 days. So no matter what plaintiffs do, there will be a period for up to 30 days where their ability to get a handgun is completely out of their control. In other words, though it does not permanently bar plaintiffs from owning handguns, the challenge law deprives them of that ability until their application is approved, no matter what they do. There is the heart of the FOID card challenge. And I would say that ours is distinguished and in a worse position because theirs is a handgun acquisition permit. Ours is when you can't own any firearm without the FOID card. So, they go on here. Our question at Bruen's first step is simply whether plaintiffs have made a prima facie case that the challenge law violates the Second Amendment. So they just need to show that the law regulates a course of conduct that falls within the amendment's plain text, i.e., their ability to possess and carry weapons in case of confrontation. Nothing in the amendment's text or Bruen says that it protects only against laws that permanently deprive people of the ability to keep and carry arms. There's a very long footnote 8 about the dissent in here, and it's half the page. It is noteworthy, and we'll probably come back to it later. Yet, under the challenge scheme, an applicant without a firearm cannot possess or carry one until they are approved, a process that can take 30 days, and the law's waiting period could well be the critical time in which the applicant expects to face danger. So the temporary deprivation that plaintiffs allege is facially plausible Second Amendment violation. There you have it. And so the court goes on here. The court goes on, accordingly, Maryland's law regulates conduct that falls within the Second Amendment's plain text. Plaintiff's challenge thus satisfies the first step. This is the proper application of New York, the proper one. Unlike Easterbrook's folly, this is the proper one. And they say we proceed to the second step. Has Maryland shown that its law is justified by history and tradition? And their answer is Maryland has not met its burden. At Bruen's second step, Maryland must provide historical evidence that justifies its law. To do this, they may identify a historical analog demonstrating that the law falls within historically recognized exception to the right to keep and bear arms. But the two historical examples Maryland cites are not relevantly similar to the challenged law, and it has offered no other historical evidence to justify its law. Indeed, Maryland admitted at oral argument that it had not presented a proper historical analog for the challenged law, noting that it had identified no founding area laws that required advanced permission before a citizen could purchase a firearm. Game, set, match. They go on to try to use the militia laws, and the court does a very good job of explaining that they didn't apply to everybody. They didn't apply to the old, the infirm. They didn't apply to women, and that you were only obligated to show up with a gun, and you could be penalized for not having a gun. Very different here. The court did a great job in breaking down the arguments. And the dissent just loses their mind, going over about this should have been remanded. The district court should have got another bite at the apple. And they hang everything on that shall issue language from the concurrence and that kind of talk in New York. But that is not carrying the day here. So this is a good piece of news. This is going to help Illinois out immeasurably in our challenge. And now we will see if the Attorney General of Maryland decides they're going to take this case up on appeal. Or are they going to get a hostile en banc panel like you see in California. It's anybody's guess which way. But this, I believe this case was argued in February. And that gives me hope that we are very, very close to getting an opinion on the Maryland v. Bianchi. That's their semi-auto ban, and that we get something else out of there. So guys, with this, it is a great 2A Tuesday. We'll have to hoist a glass of whiskey a little later this evening as we get through this. We are an hour away from the status call that we're going to have with Judge McGlynn today over the Illinois amended complaint by the Federal Firearms Licensees of Illinois, GOA, and the Gun Saves Lives people over the registration component. So we'll have more news we will be bringing you this afternoon. But right now, this is a powerful and well-reasoned, well-thought-out ruling that is just knocking holes in the anti-gun BS and rhetoric that the anti-gun attorney generals around this country keep trying to put up in front of the court, getting them to bite on this bait, and they're not having it. So, as always, please, guys, like, subscribe, copy and paste the link, share it around all your social media. We really appreciate it as we are knocking on 10,000 subscribers here at the channel. And as always, frag out.